I'm going to talk tonight about housing court, about the two basic kinds of cases that landlords bring against tenants. There'll be time for questions and answers at the end, but since we're a relatively small group, if you have any clarifying questions as we go, just put up your hand or put something in the chat, and I'll just ask Jonathan and Anna if you can keep an eye on that since I have trouble seeing that while I'm sharing my screen. Do you want to remind folks that since we're recording, if you have any questions that you feel that you want to have more privacy for, then save those till the question and answers at the end when the recording will be off. All right. Whoops. All right. So as I said before, TakeRoot Justice is a nonprofit legal services provider. We get to work with Cooper Square as well as a bunch of other organizations throughout the city that help tenants organize for power. So tonight we're going to be talking about housing court. There are actually other kinds of proceedings that happen in housing court, including when tenants sue their landlords for repairs. Um, we're not going to talk about those tonight just because altogether that would be more than we could really do justice to. So tonight we're talking about eviction proceedings, how they work, what happens as the landlord is leading up to them, what different kinds of documents look like and mean, as well as how people can respond when they get these documents. So, first of all, there are two types of eviction proceedings in housing court. One is called a non-pay, and one is called a holdover. So, like the name suggests, a non-pay is when the landlord is claiming that somebody didn't pay rent. Um, and they want to evict because rent is owed. In a non-pay, if the tenant pays the rent, the case goes away. There might be other defenses or other ways for the case to come out or other things for the tenant to argue, but the landlord can only evict if the rent goes unpaid. Every other eviction case comes under the heading of a holdover proceeding, and that's for everything except rent, right? So usually that means either somebody's lease has expired, or they never had a lease, or they have a lease, but the landlord is saying that they're doing something wrong, right? And so we'll get into the different forms that that takes. Regardless of which kind of case the landlord is bringing, there are notices that they have to serve on tenants before they can start the case, right? So they can't just start a case, they have to actually give these notices telling the person, here's what we think is going on, here's what we're basically alleging you've done or not done, and this is what you can do to avoid court. Right? So starting with non-pays, landlords are required to serve what's called a rent demand. They have to, in the rent demand, they have to state what they think is owed. They have to give a month by month breakdown of the rent that's owed. And it has to give 14 days for the tenant to either pay it or show evidence that they already paid it or that they have a defense that they shouldn't have to pay it. And the landlord can start a housing court case only if that 14 days expires and the tenant hasn't shown them anything that would prevent them from doing it. So at this stage, what can a tenant do? If you agree that the rent is owed and you don't think you have any defenses against paying the rent, uh, and if you have the money, you can simply pay what they're asking for. If that happens, then the matter's closed, it's over. There's not going to be any court case. If you disagree with the amount that is owed, either you just disagree with their accounting, or You believe you have a defense, like that the landlord hasn't been doing repairs or that they're overcharging you. This is an opportunity to bring that up to the landlord and show whatever evidence you have. But honestly, in my experience, landlords usually don't pay attention. They usually regard this as just they have to serve this thing, this rent demand, wait 14 days, and then bring a case. So there's no reason not to try to make your argument to them. I just wouldn't, with most landlords, have very high expectations that they're gonna pay much attention. Uh, if you do nothing during that time, then after the 14 days are up, the landlord will likely do what they said they're going to do and start a housing court case. This is what a rent demand looks like. I mean, it won't always look exactly like this, but you can see the basic uh, the basic elements here. It says that the landlord believes that the tenant owes some certain amount of money, in this case, $2,130. Um, Says pay it by this date. This notice says 5 days, but that's because this notice is actually back from before they changed the law. It used to be 5 days. It's now 14 days. And then if you look at the bottom, it does give a little breakdown saying how much the landlord believes is owed per month. So unless things are resolved at that stage, the landlord will bring a housing court case. And so the next thing that the tenant will see is a petition. Right? A petition is the paper that starts the court case. You might have heard of like a complaint. In other courts, they use the word complaint. In some courts, they use petition. This is the paper that says they are suing the tenant and what they're suing about, and some basic facts about the apartment and what their claim is. They have to serve it on the tenant, uh, which means they have to try first to come to the door and give it to the tenant in person. They have to try at least twice, and if they're not able to do it, then they have to uh, post a copy of it. Usually, just tape it to the door or put it under the door, and then they also have to mail a copy. If they don't do all of those things, then they haven't done service correctly, and there's going to be a defense that the case should be dismissed. The petition in a non-payment case doesn't tell you what your court date is because you don't have a court date yet. What a tenant has to do after they get a petition is they have to file an answer, and we'll get more into detail about what an answer is. But the way that that happens is typically that you go to the courthouse and you go to the clerk's office and they will give you a form and you fill it out. Only when you answer, then they will assign you a court date and tell you when to come back to see the judge. If a tenant or really anybody who's being sued in any court case doesn't answer, they can be defaulted. And a default means a judgment against the person who's being sued. And in this case, in a housing court case, can mean that the person gets evicted. Uh, Even if they had good defenses. So it's important to make sure that the tenant gets to court and files the answer within 10 days. If you go over 10 days, the court will still accept the answer, but at any point after 10 days, the landlord can ask the court for a default judgment, and you don't want to be in that position. Sometimes at this point, landlords might even give conflicting uh, mixed signals. I've definitely heard it said, a landlord tells the tenant, oh, you know what, don't worry about it. That was a mistake, or the lawyer just went ahead and filed that. We're going to work it all out. Even if that, even if they mean it, you should always answer because it may be that it's a mistake, but if they're going to make the mistake of filing a case that they shouldn't file, they're just as likely to make the mistake of going ahead and getting a judgment and trying to evict. So don't take anybody's word for it that you don't have to answer. If they didn't want to bring this case, they wouldn't have brought it. This is an example of what a petition might look like. Again, they use different forms, but the basic elements, and you see at the top, it's got the names of the parties, who the landlord is, who they're suing. Uh, it says that it's a non-payment petition. If you look there to the right of where let's see, can folks see the little cursor moving around on here?
Hmm.
Okay. So you see the names here. Over here, it's telling you that it's a non-payment. And then these are the very basic facts, right? Saying that the person we're suing is the tenant. This is the address. This is an accurate description of which apartment it is. There's a lease. This is the rent. This is what we're saying wasn't paid and which months. Um, It's actually no longer legal for the landlord to include legal fees in a case brought in housing court. They used to be able to, but thanks to tenant organizing, that has changed. So you won't see a line here that says legal fees. They will say that they've served you the rent demand, and then they're required to state whether the apartment is rent stabilized or not. They also have to say if the tenant has Section 8 or any other kind of subsidy. Those things have to be stated in the petition. And then finally, this section here, so landlords are required to register their buildings with HPD, Housing Preservation Development, code enforcement. And they have to renew the registration every year. And as part of that registration, they have to say who they are, right? And you can look that up on HPD's website. And they're required in the petition to say that they've registered, they have a current registration, and they have to give their registration number. You can look this up on HPD's website, and if in fact their registration is expired or they didn't register, that's actually a defense. They may not be able to continue with the case until they fix that. Okay. So the answer, this is the tenant's response to the petition, right? It's saying what your arguments are, what your defenses are. In order to file it, you go to the housing court, and I should have fixed that. It says 141 Livingston Street in Manhattan. It is 111 Center Street, down just north of Foley Square. You go in. If you're in Manhattan, the clerk's office is on the first floor, and if you're in Brooklyn, it's on the second floor. Um, and it may take a long time because there are lines. So if it's possible, set aside as much time as you can. But once you get there, it is pretty straightforward. You start by going to a window where they ask you what you're there for. You say you're there to answer a case. They direct you to another window. A clerk in the window goes over a form with you that has a list of defenses. And they ask if you want to claim any of these defenses. And you can raise any defenses that you want. In addition, you can also raise other arguments that aren't already listed on the form. And this is where sometimes you get some friction with the clerk. So the clerks are supposed to write down whatever you say, whether they think it's a good defense or not. And literally, the example I'm about to give comes from the chief clerk himself. Says, if a tenant says, I didn't pay the rent because aliens landed in a flying saucer and took the rent from me, the clerk is obligated to write that down. But in reality, often the clerks are in a hurry. They may be in a mood. They may say, you can't argue that. Um, so just don't take no for an answer, because any defense you don't raise, any argument you don't raise in the answer, you won't be able to argue later in the case. So it's really important to make sure that everything you can think of is here. And it's, if you make an argument and it turns out the judge doesn't consider that a valid argument, that's fine, right? There's no penalty for raising an argument that the judge doesn't agree with. But you don't want to miss an argument and not be able to raise it later. So no matter what the clerk says, don't take no for an answer. Insist that they write down any argument you think you might have that hasn't already been listed. Here are some of the defenses that are on the form that the court gives you. I won't go over all of them, and I know the print is a little bit small, but you can see the basic areas that the court has on their checklist, because these are the most commonly raised defenses, but they aren't all of the defenses. So service, you weren't served properly, you didn't get served the way that we talked about a couple minutes ago. Uh, Saying, they don't have my right name, or they didn't name me at all, even though I'm a tenant. It could be I paid the rent that they're demanding. It could be I'm rent stabilized and they're overcharging me. It's not the correct rent. The rent that they're demanding is not the rent that's on my lease. I tried to pay the rent, but they didn't take it, or their rent portal is not working. Um, uh, you can also raise that there are conditions in the apartment that need repair and that the landlord hasn't repaired them. Uh, or other things like the landlord has harassed you, or they're seeking rent from years ago and they shouldn't be able to do that. Um, Again, there are further arguments, but those are, in my experience, the most common defenses that tenants can raise. And really, I don't think there's a single tenant anywhere in New York City that can't say truthfully, there are conditions in my apartment that the landlord has not repaired. Okay, so separate from the legal arguments you can make, if you agree that you do owe the rent, but it's, you know, but you're not sure how to pay, there are resources for tenants who are in court for non-payment and need to be able to pay off arrears. The most common is called a one-shot deal. It is uh, it's run by the city, HRA, which is the Department of Social Services, and it's just what it describes. It's a one-time payment for someone who is behind in the rent for some reason. But if they can pay off what they owe, they will be able to afford the rent going forward. So the idea is that if a one-time payment will get the tenant out of difficulty and allow them to remain in their home, then the city will pay that. And so it has two things that the city wants the tenant to show. One, that they had a reason why they fell behind in the rent, but that reason is over now, and that going forward, the tenant will be able to stay current in the rent. I should also say that for most people, a one-shot deal is actually a loan from the city, and they do expect it to be paid back, but um, they generally will not do anything as long as the tenant is making even a minimal payment, like $5 a month. As long as there's some money being paid off, HRA usually holds off. It's only when people don't respond at all. And some folks, including folks who get SSI or Social Security, it's not a loan, it's a grant and doesn't have to be paid back. There are private charity organizations that help people pay the rent. There's a whole lot of them, and they come and go. So the best way to do this, instead of trying to call every single one, is to call an organization called Housing Court Answers. Great organization. They provide all kinds of support to tenants who are in housing court. And among other things, they have a kind of a clearinghouse for all the different organizations in the city that are providing rental assistance to people. And so if you call this hotline, and if you don't get that, if you don't aren't able to write down that hotline number, Cooper Square is going to share these slides later on, so you'll have access to that. And they can tell you, well, these are the organizations, Catholic Charities currently, is providing that kind of assistance, and then they can help you get in touch with them. Uh, for families with minor children in the household, or veterans, or someone who's a survivor of domestic violence, or someone who's in a homeless shelter, or the people in homeless shelters no longer have housing court cases. Uh, so these folks might be eligible for an ongoing rent voucher that helps pay the rent every month. It's called FEPS or City FEPS. I'm going to get this wrong, so somebody correct me if I get wrong, but I believe it is the Family Homelessness and Eviction Prevention Supplement. That may not be the exact acronym, but I know those words are in there somewhere. The idea is that it helps families whose rent is high, well, not high, but whose rent is above what they can pay uh, because their income is below a certain level, and there's a minor child in the household, or they're a domestic violence survivor or a veteran. And the great thing about a FEPS or a city FEPS voucher is that it's continuous. It pays a certain amount of the rent every month going forward, and is portable. You can take it with you if you move to another apartment. There's also Section 8, which is in some ways similar to city FEPS or FEPS. I think it's much more well known. It's federally funded. It's a voucher that pays a part of the rent every month. And the tenant's part of the rent is limited to 30% of their income. So if somebody's income goes up, then they pay more in rent. If somebody's income goes down, they pay less in rent. Section 8 is great if you can get it, but it is very scarce, and the federal government has not, in the last 30 years, been very supportive of continuing to fund it. So the wait list is very long, and has in the past been closed for a while. There are some other rental assistance programs that work something like City FEPS or Section 8. For the most part, they're very specific and aimed at just particular uh, populations. So I won't go into all of them here. In general, if you call the Housing Court Answers hotline, they can give you a more comprehensive picture of what all might be available. Okay. So I want to back up then and talk about the other kind of eviction case, which is a holdover. So again, holdover is literally every kind of eviction case that's not about rent. And of holdovers, they're basically split into two groups, right? There are no cause holdovers, where it is not based on anything that the tenant did or didn't do. It could be that the landlord simply chooses not to renew the lease or the month-to-month tenants, or the person never had a lease and was not a tenant. And in those cases, again, the landlord can simply say, I just don't want to rent to you anymore. And they don't have to show that the person did something wrong. This does not apply to rent stabilized tenancies or tenancies that are covered by the new good cause law. Under rent stabilization and good cause, there literally is no such thing as a no cause holdover. Uh, exactly how to know if you're rent stabilized or covered by good cause is subject, I think, of a whole other workshop, which which we do sometimes. We're not going to go into those this evening just because there's not enough time to cover all of that, but just to say that rent stabilized tenants and tenants who live in good cause covered apartments are protected against this. And to say that it's a major goal of the housing movement that everybody should be covered this way, that nobody should be in a position of losing their housing for conditions that they have no control over. But we're not there yet. Tenants in general who live in housing with less than 6 units, small buildings, co-op condos, people who are subletters, or people renting with very high rents are generally not going to fall under rent stabilization or good cause. There are also the other group of holdovers are for cause holdovers, meaning that the landlord is saying that the tenant did something or failed to do something, and that's why they're evicting them. And so uh, this is a kind of holdover that can be brought against rent stabilized tenants, good cause tenants, can be brought in the middle of a lease. Ordinarily, a landlord can't evict anybody in the middle of a lease because the lease is for a set period of time. But the landlord can bring an eviction case in the middle of a lease if they're alleging that the tenant breached some requirement of the lease. The tenant has created a nuisance, meaning they've engaged in conduct that's dangerous or harmful to other people around them or to the building. If the tenant does illegal conduct in the unit, so for example, is arrested for dealing drugs out of the unit. The tenant has not signed a renewal lease or not agreed to a lawful rent increase. And then finally, and this is a lot less common than it used to be, but landlords can take rent stabilized or good cause apartments if they plan to use it as a home for themselves or someone in their family. We used to see a lot of those cases before 2019 because it was a convenient way for landlords to get rid of tenants. They would simply claim, "I plan to move in." They would evict the tenant, and then if you went around a year later, you'd find that they were still renting the apartment out. Starting in 2019, there were major changes to housing law in New York because of years and years of organizing by the housing movement, including Cooper Square Committee. And so now it's not as easy for landlords to take apartments out of rent stabilization, and it's not as easy for them to raise rents on rent stabilized
Oh,
apartments. So they just have a lot less incentive now to try to get rid of tenants by any means possible. And so we see a lot less of these, what we call owner use holdovers, because it's really no longer, very profitable to tenants to bring, I mean, to landlords to bring these, unless they genuinely do want to use the apartment as their own home, which is and really always has been quite rare. Most of those holdovers have always been a pretext. So just like with a non-pay, before a landlord starts a holdover, they have to serve some notices. And what kind of notice they have to serve depends on what kind of holdover it is. So if it's just that the lease is expiring, then they have to give a notice in advance saying that they don't plan to renew the lease. And how far in advance they have to give that notice depends on how long the tenant has lived there. If the tenant's lived there a year or less, the landlord has to give 30 days notice that they're not going to renew the lease. If the tenant's been there 1 to 2 years, they get a 60-day notice. And if the tenant has lived there longer than 2 years, they get a 90-day notice. And if a landlord serves these notices late, they have to wait for the 30-day or the 60-day or the 90-day period to run out. So even if your lease ends on, say, February 28th, if the landlord doesn't give you a notice until February 27th, they got to wait another 30 or 60 or 90 days before they can start a housing court case. Under the good cause law, if a landlord says that there is a cause to evict the tenant, then they have to give a notice saying what is the reason, what is the cause, uh, and they have to give some details about that. Similarly, for rent stabilized apartments, if it's a cause, they have to do more than simply say, you're making noise or you're a nuisance. They actually have to give some details so you know what they're accusing you of, and you have some notice so when you go to court, you can defend yourself. Finally, there are holdovers where the person who the landlord is seeking to evict isn't a tenant, meaning they never had an agreement to be there and pay rent. They might be, a roommate or a family member of a tenant who's since moved out or passed away. So they don't have rights of their own to stay. That the name for a person in that position is a licensee, meaning that they have permission, license, to be in the apartment, but not a lease, not a tenancy. And a license or permission can be revoked at any time. So a licensee is a very vulnerable position to be in. And before a landlord brings a holdover against a licensee, they only have to give them a 10-day notice. Um, so landlords, among other things, very much want to claim that the people they're evicting are licensees. And that may not always be the case. But if they can say that somebody's a licensee, they don't have to give as much notice, and it's much easier for them to win the case. But again, we see plenty of cases where the person who's being called a licensee actually is the family member of the tenant and they have succession rights. Or, they really are the tenant and the landlord is just not being truthful. This is an example of that kind of notice. I see John's hand. Yeah.
Yeah, hi. So I'm a licensee. I live in a two-family house with like 12 people, so it's a not really legal rooming house situation. And I was given a 10-day notice. I was handed a 10-day notice by the brother of the
Eviction
deceased.
101.
Excuse
Yeah.
me. I was handed a 10-day notice by someone who is both a family member and who does work for the new owner, the new administrator of the estate. I understand or suspect that that's not proper service.
Uh, it could be the service requirements for notice to quit are a lot looser than for actual court papers. Um, so I'd want to, before going into that, I'd want to have a more detailed conversation about the facts. I would also say I wouldn't necessarily assume that you're a licensee. Um, if there was ever a point at which you had an agreement with the owner that you would be able to live there for a certain period of time in exchange for paying rent, they might not call you a tenant. They might not, have given a written lease, but you would still be a tenant. So that's the kind of thing I'd say is worth talking to a lawyer, me, or one of my colleagues in more detail, just to make sure and not accept what the landlord says about that you're a licensee.
Okay, so let me expand upon that. So after the 10-day period expired, the next day or a couple of days later, I got served summoned to appear in housing court. So formal
Hmm.
eviction papers were served to me the same way by the half brother of the deceased former main occupant and rent collector where I live, and who is also the uncle of the new administrator of the estate who is trying to evict me. So again, he handed it to me. Is that proper service? And I went to housing court
Um,
today, and I got an
yeah,
extension
if it's handed to you in person, that's generally always going to be proper service.
by a family
And
member.
yes, so the law says that anybody except the party themselves can serve papers. There is a limit on how many times per year a person can do service if they're not a process server. Uh, but if they do it once, that is legal. The only person who can't do it is the party, the person who's named as the landlord. I just want to, here is a look at one of the kinds of notice that people get before a holdover. This is a notice claiming that the person is a month-to-month tenant, meaning their tenancy is renewed every month when they pay rent. This is a notice saying that we do not choose to continue this tenancy, and it gives a date by which they wanted the person to leave. Otherwise, they would bring a holdover. In this case, they did bring a holdover, and we went to court. And actually, we were able to fight the eviction because the person actually had a defense that the landlord was retaliating against them for making complaints to code enforcement. Okay, so if the landlord is alleging that the tenant breached their lease, they actually have to serve two notices ahead of time. The first one is a notice to cure, which says, we believe you're doing such and such conduct. You have a pet when your lease says you can't have a pet. You are making noise and bothering other people. You have 10 days to correct this. And if you do, the matter is over. If they believe that the tenant has not corrected, has not cured the violation, then after 10 days, they can then serve them a notice of termination saying, you didn't cure, you didn't stop doing the thing. And so you have 10 days to leave, or there will be a housing court case. The next step after the notice is a holdover petition. It is generally, it's going to look just like a non-payment position, but there is one key difference. Unlike in a non-pay, the petition will give you your court date, and you do not have to go to the clerk's office and answer before then. You just need to show up in court on the court date that's listed. When the tenant is in court on the first court date, they can tell the judge any defenses they have. Tenants can file answers if they want to. It's just not required. And if a tenant doesn't file an answer, there's no default here. You just go straight to the first court date. All right. Now we're skipping over most of what happens in the middle of a case. the defenses and the arguments and, how trials work and motions. And the reason for that is that, like a couple of other things that came up here, those are workshops in and of themselves. And in order to do justice by them, we really have to dedicate a whole other workshop to them, which we do, and which I hope we'll be able to come back and talk about. But here, I just want to talk about what are some other stages in a court case. Now, housing court cases, actually for every kind of court case in every kind of court in America, 95% settle. And it's no different in housing court. So most housing court cases end with a settlement. The piece of paper, the written agreement, the settlement is called a stipulation. That's the written agreement between the parties, between the tenant and the landlord, that settles claims the landlord's bringing, the defenses the tenant is raising, says what's going to happen now. The case will be dismissed, or the tenant will move out in 3 months, or the landlord will do some repairs and the tenant will pay some money. Uh, both sides sign. And if a tenant is, or anybody is in housing court without a lawyer, the judge is required to go over the settlement in detail with the person, make sure that they understand what they've signed, that it's what they meant to do. Uh, it's in truth, a little hit or miss. Some judges in housing court are very careful about this and will spend time going over all the details. And if they find that the tenant didn't actually understand some part of it or disagrees with some part of it, they will tear it up and call the landlord's lawyer back in and make them do it again. Some judges will just run through and just say, "Do you agree with this?" and you're out. Um, the first is actually what judges are supposed to do according to the law. But I don't think it's going to be a surprise or news to anybody here when I say that what happens in court is not always what the law says is supposed to happen. And that, in fact, a lot of what happens in court, and this goes for any court, uh, has just sort of a vague relationship to what the law says is supposed to happen. Nobody has to sign a stipulation. When tenants go to housing court, typically the landlord's lawyer calls them out into the hallway and shoves a piece of paper at them and says, if you don't sign this, you're going to get evicted. And there's a lot of pressure. But nobody has to sign anything. All tenants have the right to at least one adjournment, which is a rescheduling, putting the case over to the next day, which is usually about 30 days out. No questions asked. You can ask for that and you have the right to it. You do not have to agree to anything on the first day. In addition, the city has a right to counsel program. This is supposed to mean that any tenant in housing court whose income is below a certain level is given a free lawyer. In reality, the program has struggled to get up to speed and has struggled to get enough lawyers. So not everybody who qualifies for right to counsel winds up getting a lawyer. It is getting better every year. And uh, there is still a fight to fight by the housing movement to make sure that the city gets it up to speed. In reality, what will happen is any tenant who appears in housing court without a lawyer will at least get to talk to a lawyer. And it may be that the lawyer's not able to represent them beyond that conversation. It may be that the lawyer is able to represent them. But all of this is to say, Nobody should go out in the hall with the landlord's lawyer if they haven't talked to a tenant lawyer first. And the safest thing to do is just say, I want an adjournment so I can talk to a lawyer. Uh, and for what it's worth, the landlord's lawyers have gotten so used to this now that they just kind of automatically assume that the tenant is going to ask for an adjournment, and they just go to the clerk and ask for the next court date. So, okay. Hopefully, you never get to this stage, but if a tenant has lost a court case, either they signed a settlement agreeing that they'd leave by a certain date, or the court ruled against them and gave the landlord a judgment saying they could evict the tenant, the next thing that the tenant gets is the marshal's notice, right? So the marshals are uh, people who are authorized by the city to conduct evictions. Uh, and landlords hire them. The landlord can't do an eviction themselves. They can't change the lock. They can't remove somebody's stuff. Only a marshal can do it. And so after a landlord wins a housing court case, they go and they hire a marshal. The marshal serves a notice on the tenant by mailing it to them or putting it on their door. And it says, and this actually should no longer say 6 days, it should say 14 days. Uh, Obviously, I have to update some of these slides. The good thing is that that's because the tenant movement keeps winning good changes in the law. Uh, Quickly enough, actually, that we're not doing a good job of keeping up with them in our materials. So the notice says, this is a notice from Marshall. You are going to be evicted, and the earliest possible date to be evicted will be listed on the notice, and it should be 14 days after the tenant gets it. At this stage, if there's an agreement from the housing court that says you will pay, you can still pay the rent or you can still do something to avoid eviction, but the tenant needs more time. They go to housing court and they file what's called an order to show cause to try to get more time. So an order to show cause is the paper that you file in housing court that is asking the judge to set another court date and order the parties to appear, right? Uh, so they can also, when the judge signs the order to show cause, will usually include a line that says the marshal is stayed from doing any evictions until this court date. So it'll hold off the marshal until you get a chance to go to court and argue that you should have more time, or uh, you know, get the one-shot deal or the FEP so that you can pay the rent. Uh, to do it, you go to the same place that you go to answer, which is the clerk's office, which is on the first floor in 111 Center Street in Manhattan, or the second floor at 141 Livingston Street in Brooklyn. And you go to the first window, they say, "What are you here for?" You say, "I want to file an order to show cause." They will send you to the window for that. And the clerk there will give you the forms. The forms are not super long. They're not designed for lawyers. They're designed for ordinary people. And in it, you fill out what you're asking for, and as detailed as possible, a description of why you need it, including if the tenant is asking for more time to pay off rent arrears, a detailed description of everything that the tenant has done so far. Because judges, if you ask them for more time, want to know, have you tried everything possible? Have you been diligent, but you haven't been able to meet the deadline, despite your diligence. So you want to be very clear that you haven't just been sitting around waiting for the deadline to appear. You can attach anything you want. to the order to show cause as evidence. Once again, clerks sometimes tell you that you can't because they just don't want to deal with it. That's wrong. Don't take no for an answer. And generally, they'll yield. So if you want to be like, look, here's documentation showing I've been to HRA 5 times working on my one-shot application, that's a good thing to attach. I mentioned housing court answers earlier. They're the ones you can call to get connected to private organizations that might be able to help with rent. The other thing housing court answers does is they have a table in every housing court right there by the clerk's office. And their job is to help people fill out these forms. So if you go to the housing court answers table and say, this is my situation, and I'm filing an order to show cause asking for this reason, they help people do it. They can sort of walk you through it, say what are the best things to write, what are the, details to include. Um, and they are very experienced and they're very dedicated, and I highly uh, recommend going to them. Yeah, I talked some about right to counsel. So again, you may be able to get a free lawyer. Uh, right now, the service is limited to people whose income is below 200% of federal poverty level. I'm not going to go into what those numbers are right now. If you Google 200% federal poverty level, any of the first 5 things that pops up will just take you straight to a chart. It's based on household size, so there's a different number based on how many people are in the household. It is unfortunately pretty low. The federal government does not increase the federal poverty level very much, generally because uh, any presidential administration that raises the federal poverty level will be the administration under which poverty increased. So none of them ever want to increase the federal poverty level very much, which means that it's ridiculously low, unfortunately. Like I said, even if you are eligible, there are not yet enough lawyers to represent all of the tenants who are eligible, but it is getting better. It's just taking time. It's a lot of lawyers who are getting hired by places like Legal Aid and Legal Services. It's a bit better every year, but it still has not reached its potential of actually providing a right to counsel. I don't expect you to write down all of these websites. Uh, but these are websites that can be helpful in researching your landlord or your building or the code violations in your building or looking up the status of your case in housing court. Again, Cooper Square is going to send out copies of these slides, so you'll be able to just click on any of the links in here.